To which this court was of the view to first entertain the hearing as to whether it had the jurisdiction to entertain the application for the grant of the mandatory bail as sought. On the other hand, however, the prosecution opposed the application, arguing as follows. The Land State Attorney Bruce Tuanjire submitted that when the court adjourned on the 3rd of October 2025, the trial magistrate made a ruling on the application for bail for all the accused persons. And that the land trial magistrate was on leave, therefore, what was anticipated in the circumstances was to mention the case or seek review of the ruling of the trial magistrate which denied the accused person's bail. But not seek a fresh bail application before this court. He emphasized that the court had no jurisdiction to try the case before it, and cited the case of Uganda versus Katanga Mori and furthers capital case number 1 of 2024, where the court stated that the gravest offense on the charge sheet determines the jurisdiction of the court. That the court was therefore required to advise the respondents that it did not have the jurisdiction but apply before a competent court. He also contended that jurisdiction is a matter of law and it cannot be for this court to entertain a matter that is not rightly before it. He also prayed that the court expunges the record before it on grounds that it was before a wrong court. That it is the court with jurisdiction that reserves the discretion to grant or deny bail. And that section 76 of the MCA did not intend that any judicial officer entertains and grants bail under such circumstances. The submissions were supported by the Land Chief State Attorney Sharon Nambia, and of course the position of the court is that it agrees with the prosecution that one of the issues for determination before this court relies on whether the court has the jurisdiction or not to grant such a prayer by the defense. In rejoinder, counsel is contended that when a matter of law is raised, then the court has to hear it, and a decision therefore has to be made by the same court. And that the basis for such a decision then cannot be to expunge the record, You'll excuse me, my interpreter is lost, but let me find it now. What I'm saying. Anyway, I'll repeat that. In rejoinder, counsel is contended that when a matter of law is raised, then the court has to hear it, and a decision has to be made by the same court. Ensonga ekwatagana n'amateeka kooti erina okuwuliriza ate era nesinzira kuwuliriza okunendoka esala naye kikusazaamu busaza emibeera ewulizeganya
kooti erina okuwuliriza nekola okusalawo wabula sikugenda maaso okusalamu busazi ebyewulidde olwakuba nti biri mu kooti ekyamu.
And therefore, the application to expunge would be unreasonable and offends the principle of the right to be heard. Counsel submitted that this is a human rights matter, and this court agrees with the submissions of the Land Council in that respect. But the court record and the basis of this application cannot therefore be expunged, as it would imply doing away with the same record upon which this ruling has to come from. Bail is indeed a matter of right provided for under Article 23(6)(b) of the Constitution, including the provisions relating to mandatory bail under Section 76 of the MCA. This court has therefore listened to the submissions of both the defense and the prosecution. However, the court has had to address its mind to the provisions of Section 76(b), which provides as follows. I will read it verbatim, that if an accused person has been remanded in custody. This is not about them, it's about but generally an accused person. Yes. That if an accused person has been on remand in custody before his or her trial commences, the magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail on his or her own recognizance, that he or she is accused of an offense referred to in Section 75(1) and specifically Section 75(2)(1)(j), which provides as follows. That for any other offense in respect of which a magistrate's court has no jurisdiction to grant bail. In other words, the court can release the accused person on any other offenses, but specifically under Section 75(2)(1)(j, it limits the offenses with regard to those which the trial court has no jurisdiction to grant bail. 75(2)(1)(j. So from the foregoing provisions of the law, this court has no jurisdiction to release A1 and 2 on mandatory bail as prayed by the defense. And the application is accordingly dismissed. However, the accused persons have the right to freely apply for the same before the trial magistrate who is back on leave. I saw order. So just for guidance of court, the accused persons are all here today because we did not fix any other date for mention or hearing of the same matter. So that is what we will proceed on, and I've been guided by the clerk, the trial magistrate, that the dates are available, either 18th or the 21st of November. That will be a Tuesday or Friday. It will either be a Tuesday, 18th will be a Tuesday, whereas 21st will be a Friday.
But of course,
I'll hear from the 12 of you then. We have those two available dates.
Your Honor, adjournments at this stage are governed by law, particularly when somebody is in remand. It's not a discretion of convenience.
Just a minute. Just a minute. Let me hear you. Yes, Counsel.
Worship, adjournments when an accused person is on remand is governed by law. The law does not allow that he stays in custody beyond 2 weeks.
14 days.
14 days. So we are asking that you take into account as you are granting those provisions so that the court does not acquiesce in further violations. And when one is on bail, then that latitude is granted, maybe a month or so. So we are asking that we play within the rules. This is a court of justice.
Just a minute. Have you spoken on behalf of all the rest of the defense?
Yes.
Yes.
With a lot of respect to my learned senior brother. First of all, he has not afforded the court the witness now, but he must be that as it may. This is what we've just been through just a few moments ago. The proposed dates, I believe, were given by the trial magistrate. Your Honor, I assume it is based on the business of the day. And if I am correct, Your Honor, fixing of cases is also, let's not be very academic, Your Honor. I think it is based on the work or rather cases that are fixed. I appear in that court personally, and I know that there are several other cases that are lined up for that day. Your Honor, to avoid the back and forth, the two options the court had given was the 18th and 21st. They have proposed the 18th, proposed the 21st. Your Honor, it is now up to you. Since you have been given 2 days, Your Honor, we propose the 21st, Your Honor. So the decision before you is whether the 18th or the 21st. My humble submission, Your Honor.
In addition, Your Honor, the prosecution is constitutional court to the Constitution adjournments for courts of jurisdiction practice directions of 2019.
The constitutional.
Constitution brackets adjournments for courts of jurisdiction brackets open bracket practice cross practice directions.
Oh.
Your Honor, these directions govern the courts of issues with adjournments. And Your Honor, this court has already shown that.
What is the provision you are relying on?
Yes, the directions, Your Honor. Your Honor, I'm referring, there's more. Anyone can read them in 5 minutes. Your Honor, these directions so that.
Which, for the record, please cite the direction, the relevant direction.
I'm quoting the 2019 practice directions, the constitutional adjournments for courts of judicature, practice directions of 2019.
What do they say in particular?
Yes, court previously has given sufficient cause as to why it cannot entertain this matter before, and these directions say, Your Honor, that if court shows sufficient cause why it cannot grant an immediate adjournment, it shall adjourn to the date that it feels it can handle that matter. Summarily.
Yes, I
Your
want.
Honor, this court.
Just a minute. Can you help this court to be guided by the particular provision of the guidelines that you're reading?
Right now in the
or quoting?
Your Honor, it's the practice direction, and they are too small. I refer the court to refer to them because the prosecution.
Please, you are the one making the submissions. Can you quote the particular one? You have cited the law. So which?
Your Honor, can I finish then I will cite it? Can I submit, Your Honor? So Your Honor, this court has shown sufficient evidence that when the other dates before the 18th and the 21st, there are other cases like my land colleague has brilliantly submitted. That those cases, on those dates before the 18th and the 21st, this court has other cases to handle. We therefore pray for either the 21st or the 18th. We so pray.
May I? Your Honor, Your Honor, the balance, let's take 18. The first case, we shall take 18. November.
Also,
Okay, I've listened. Let me make a brief ruling to that effect. So state, should we fix the matter for hearing? Cabinet? Okay, since the the guidance I received from the trial magistrate, the dates are available, 18 or 21st of November 2025. In the interest of justice, I adjourn the matter from mention on the 18th of November 2025. Accused persons are all further remanded.
People power.
Power, 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 people power.
So let's first adjourn. Let's first formally adjourn, and then we really leave you to enjoy your rights. It also in silence. Let's first adjourn court, and then we will let the rest of the process take its course.
People power. Power, power. People power. NUP. Everywhere. Everywhere. NUP. Ra. Cha. Cha. Cha.
Hello.